Welcome back to this third segment in this law session of English Legal Systems, CLRI, as it relates to the role and operation of the courts. Now, before the break, we were looking at, or rather we looked at, the Supreme Court, and I certainly hope I've left you with some sort of further thinking to do in respect of whether it is a Supreme Court or just this Supreme Court, meaning is it just a final appellate court and nothing more. We are, of course, going to explore the other courts within this framework, but I would certainly urge you to look at the law session relating to judges, meaning the judiciary and the magistracy, because it is fairly intimately linked with this law session as well, because we've got the courts, but we also have the actors and the players within it, and I would urge you to ensure you familiarize yourselves with that. All right, we started with the highest court looking at the Supreme Court. We did flag up, for example, that you need to consider the ECJ, or the Court of Justice of the EU, in the framework, but as it relates to the UK, please bear in mind, final court of appeal is, of course, the Supreme Court. Just below that, and then on the next rung of the ladder below, is the Court of Appeal. Now, the Court of Appeal sits at the Royal Courts of Justice in London, and it is divided into two divisions, the Civil Division and the Criminal Division. The Criminal Division hears appeals from Crown Court cases, while the Civil Division receives appeals from the High Court, from tribunals, and of course, in some cases, from county courts. Now, the judges are known as Lord Justices, and it is written as LJ following the judge's name. Now, the Civil Division is headed by a senior judge known as the Master of the Rolls, written as MR, and is referred by whatever title is appropriate at the time. As I say, the suffix MR is what is generally used. Now, the Criminal Division will hear criminal appeals against either conviction, against sentence from the Crown Court. And criminal cases will normally be heard by at least 2 or 3 judges from among the Lord Chief Justices, the Lords Justice of Appeal, Court of Appeal, and the judges of the High Court. Now then, even though I am laying this out in a format for you to understand the structure, it is highly unlikely that you're going to get a question that says, tell me about the courts of England and Wales. And you're going to say, the Supreme Court does this, and this. The Court of Appeal does this. It is unlikely, because the idea of studying law, of course, is critical thinking. So the information I give you, the question then is, what do I do with it on an exam paper? Well, in this particular area, the discussion tends to be about the Court of Appeal being this final court for the majority of cases, and what does that mean? Well, when we look, for example, at the idea of the development of the common law, and we see judicial activism, we have seen, for example, judges like Lord Denning, who has taken this two-pronged approach to be the kind of final arbiter in respect of certain legal principles, and doing this at all times sitting in the Court of Appeal is the kind of things to consider here. So you need to know what it is that the Court of Appeal does. You need to consider a case like Young and Bristol Aeroplane, and then see how that fits in to the whole hierarchical structure, because the Court of Appeal is certainly below the House of Lords, but the fact of the matter is, it tends to be the final court for the vast majority of cases, because the Supreme Court from the House of Lords is not going to take on board just every and any case. You have to seek permission from the Court of Appeal to go to the House of Lords, and if that is refused, you then seek permission from the House of Lords, and that may very well be refused, in which case your matter and its final determination remains in the Court of Appeal. So what I would want you to do when you consider, for example, the Court of Appeal, is to look at Lord Denning's approach while he was sitting in the Court of Appeal, having left the House of Lords, and see how the hierarchical structure has been, I don't want to say compromised, but it has been impacted by decisions such as made Bidening in various cases, not least Galley and Lee, and cases like Millie Andrews and George. Have a look at them and see how knowing the structure helps you to understand the cases. The next court below that, of course, is the High Court. It also sits at the RCJ, the Royal Courts of Justice in London, as well as some major court centres around the country. Now, the work is handled by 3 divisions depending on the subject. So the Chancery Division deals with equity matters, trust matters, tax, bankruptcy. The Queen's Bench Division deals with contract matters, tort, and commercial matters. And of course, the Family Division deals with divorce, children, and probate. Now, the Divisional Court of the High Court sits in the Family and Chancery Divisions, and it hears appeals from the Magistrates' Courts and the County Courts. The Administrative Court in the Queen's Bench Division deals with a variety of judicial review matters. Judges sitting here simply are known as High Court judges. When we turn to the County Court, which is the next rung down, we have the County Court and the Crown Court on the same sort of level. The County Court is where the majority of civil actions are heard in approximately 280 county courts around the country, which also handle some family and bankruptcy hearings. Now, the manner in which each case is dealt with depends on the value of the claim, and so the time and cost spent on the case must be shown to be appropriate to its value. Now, sometimes when you look at this whole framework for the civil procedure rules, we see that when you look at matters being brought in the county court versus the high court, the value of the claim has something to do with that. So, for example, matters of a certain amount, approximately £50,000, will generally start in the High Court. That's not to say it must, because if it is not that complex, if the reason that the matter or the incident is £60,000 is because somebody has run into the side of my very posh Bentley motor car, and there is no issue of law of particular significance, it's only valid £60,000 because of the value of the asset. It may very well be something that is amenable to go to the county court, because a judge in the county court can deal with that. So when you look at value, that may be determinative sometimes as to whether or not the matter is started in the county court versus, of course, the high court. When you look at the Crown Court, this is where the more serious criminal offences called indictable only offences are dealt with. Now, when you look at the types of offences, they tend to either be, they tend to be either way offences or indictable or summary offences. Now, summary offences are definitely going to start in the magistrates' courts. If it's indictable only, it will of course start in the Crown Court, but it may be an either way offence, meaning that it may be considered indictable, it may be considered summary, depending on what exactly the facts are. Now, it means that it can start in either court, depending on the selection. So, we see, for example, indictable offences or other types of offences where the magistrates' courts has passed this on to the Crown Court for it to be heard. It will usually be heard by a judge and jury. Now, some cases, as I say, fall in between, and they're called either way cases, and they may be heard in either court, this magistrates' court or the Crown Court. Only Crown Court judges have the power to pass sentence above a certain level of severity. And so some cases may actually be transferred from the magistrates' courts for sentencing once a verdict has been reached. So let's say you say, right, it's an either way offense. I want it heard in the magistrates' court. If it is that you're then convicted and the magistrates are of the view that their sentencing powers are limited based on your offense, they may very well then commit it further for sentencing in the Crown Courts. Now, there are approximately 78 Crown Court centres throughout England and Wales. We then move on down the ladder to the Magistrates' Court. Now, most minor criminal cases, which are summary offences, meaning that you've been summoned in respect of these offences, tend to be heard in local magistrates' courts, either by a panel of lay magistrates who are assisted by a legally trained clerk or by a legally trained district judge who sits alone. Now, another name for magistrates, of course, is justices of the peace. And so a magistrate is largely an unpaid person. I would urge you to, as I said, ensure that you listen to the law session which relates to the judiciary and the magistracy, because it does outline what the differences are and it gives more information as to magistrates. That said, however, when you look at the role of the magistrates' court, as I say, it looks at lower level offences, but funny enough, even for the indictable only offences, what is not very generally well known is that at least 90% of criminal cases will start in the magistrates' court. It's just that it then gets committed up to the Crown Court. In the magistrates' courts, they also deal with some family proceedings, as well as it houses the youth courts. As I say, a vast bulk of criminal cases tend to be tried by the magistrates' court. The vast majority of them get started in there. The even less known fact is that the bulk of them get dealt with within that court. So you get that most criminal cases are actually dealt with in the magistrates' court, because most criminal matters tend to be minor. Somebody has gone out for a Saturday night, done something silly. He has to go before the criminal jurisdiction in respect of the matter, and that criminal jurisdiction, of course, is the magistrates' court. It gets dealt with. It never goes to the Crown Court. Remember that the Crown Court is reserved for the more serious matters. Now, the court also, magistrate court also has civil jurisdiction to hear some liquor licensing matters, some tax arrears matter, matrimonial matters, and as it relates to the criminal matters, I cannot emphasize the point that it tends to get dealt with at Crown Court level, which gets sent from the magistrate. Now, at magistrate court level, you have, of course, summary offences, not so serious. So you're looking at motoring offences, minor assaults, where the defendant is not entitled usually to trial by jury. These are usually disposed of by the magistrates quite quickly. Either way offences, as the name implies, these can be dealt with by either the magistrates or before a judge and a jury at the Crown Court. Now, such offences include theft, handling stolen goods. A defendant may, of course, insist on his right to a trial in the Crown Court. Magistrates can also decide that a case is so serious that it should be dealt with by the Crown Court, which, of course, can then impose tougher sentences above what the magistrates can give. As it relates to indictable-only offences, such as murder, manslaughter, rape, robbery, these must be heard by a Crown Court. Now, if the case is indictable only, the magistrates' court will generally decide whether to grant bail, consider other legal issues such as reporting restrictions, and then pass the case on to the Crown Court. Who then are magistrates? As I say, they are justices of the peace, as they are also known, are local people. They volunteer their service. They do not require any formal legal qualification, but generally there is some training program that they would have gone through. Generally, they have a qualified clerk who sits with them. District judges are legally qualified, paid full-time professionals who sit as a magistrate. They used to be called stipendiary magistrates. It's not the name anymore. It's now district judges. Now, they will generally hear the more complex and sensitive cases. Across England and Wales, there's about 30,000 magistrates, about 140 DJs, district judges, and deputy district judges, about approximately 170 or so, and they operate in about 330 magistrates' courts across England and Wales. We're going to take a short break, and as we return, we will look at other types of courts or court frameworks. We're going to look at tribunals when we return after the break.